case we have never met, I'm Michael Price, and I want to help you succeed in growing your business.
Welcome. Today is April 2nd, and I'm Michael Price, your host.
And I'm Nancy, your co-host.
Imagine like walking into a courtroom where the judge speaks a language that sounds perfectly like English, but every medical word you use has a completely different legal meaning.
Oh yeah, that is exactly what it's like.
Right? Like you say pain and they hear unquantifiable. You say injury and they hear unconnected.
Mm-hmm.
And that is the reality that millions of veterans face when they're, trying to unlock their VA disability benefits. It's a system that is incredibly complex, deeply frustrating, and, profoundly important. So today, to you, the listener, we are going on a custom-tailored mission to decode that language.
It really is a labyrinth of a system.
Oh, totally.
And to help navigate it, we are synthesizing a massive stack of sources for you today in this deep dive.
Yeah, a lot of material.
All right, we're pulling apart the VA's own internal adjudication manuals, the overarching legal frameworks, specifically the Code of Federal Regulations, which is known as the 38 CFR.
Right, the actual law.
Exactly. And we also have some highly revealing insights from the Claim Raven platform. We even have an expert breakdown from its creator, who's an Army combat veteran, who built these specialized data tools to decode how this entire bureaucracy actually functions.
Okay, let's unpack this, because getting VA benefits is clearly not just about being injured in the line of duty, right?
No, not at all.
It is, at its core, a highly specific legal translation game.
Yeah.
You're tasked with taking your lived medical reality and kind of forcing it into a very rigid bureaucratic framework.
That's the perfect way to put it.
But before we get into the high-tech tools or the legal loopholes hidden in the manuals, we have to establish the bare bones requirements.
Right, the foundation.
Yeah, because the sources are absolutely clear that there are 3 foundational pillars you must have for any successful claim. And if you miss one, the whole house just collapses.
Yeah, those 3 pillars are completely non-negotiable. Pillar number 1 is proof of service and eligibility, which basically establishes your window of opportunity. So the VA looks at your DD-214, which is your official military discharge paperwork.
Right.
And they use that to verify your exact entry date, your exit date, and your character of discharge. They need a defined chronological box to know exactly when you were under the military's watch.
Which means simply surviving a deployment doesn't, automatically grant you benefits.
No, it doesn't.
The VA needs proof that the service actually left a lasting mark on you, which brings us to pillar number 2, a diagnosed condition.
Exactly.
But I do want to push back on the terminology here for a second, because the phrase VA disability trips a lot of people up.
Oh, absolutely.
Like, if you're listening to this, you might be thinking, well, I'm not in a body cast, I'm not missing a limb, I'm walking around, going to work just fine, so I'm not disabled.
Right. People think disability means catastrophic.
Exactly. But the VA isn't just looking for catastrophic visible injuries. They're looking for chronic diagnosed conditions. We're talking about severe migraines, sleep apnea, gastroesophageal reflux disease, or GERD, and severe joint arthritis, conditions that have ongoing residual impacts on your daily life.
And that distinction is just paramount. It directly feeds into a massive psychological barrier that we see documented throughout the veteran community.
The military mindset.
Yeah, the military actively conditions service members with the suck-it-up mindset. You're taught from day one in basic training to rub dirt on it, take some Motrin, drink water, and whatever you do, avoid sick call.
Because going to the doctor impacts the mission.
Exactly, and people internalize that. They really do. They start believing they don't deserve benefits because, someone else had it worse, or just out of sheer pride.
It's the ultimate catch-22, honestly.
It is.
The exact survival mechanisms the military instills in you, like ignoring pain and avoiding the clinic to finish the mission, are the exact things the VA uses to deny your claim later.
Yeah, because there's no paper trail.
Right. Because without medical documentation from your time in service, you are missing the final, most difficult piece of the puzzle, which is pillar number 3, the Nexus.
Ah, yes. The Nexus is the vital link. It's the bridge connecting your current diagnosed condition today back to an event or onset during your specific time in service.
That DD-214 window of opportunity we just talked about.
Right. You have to prove the condition started there. And understanding this nexus requirement highlights a massive divide in how these claims are processed. Because the difficulty of proving that link is entirely dependent on your timeline.
The timeline divide. Okay, let's look at the absolute best case scenario first. The BDD program, or benefits delivery at discharge.
Yeah, this is huge.
If you are active duty and you're like between 90 and 180 days from getting out, not on terminal leave, but actual physical discharge, you are in what the sources call a huge opportunity window.
Oh, absolutely.
I like to think of the BDD program as having a VIP fast pass to the Nexus.
It is the closest thing to a golden ticket in the system. The VA prioritizes getting transitioning service members squared away before they exit. They aim to start compensation payments within a month or two of discharge.
Wow, that's fast.
It is, but the real power of the BDD program isn't just the speed of the checks. It's how it completely bypasses the Nexus problem.
Right, because you're still in.
Exactly. Because you are still actively serving, any diagnosis you receive, say you go to medical for a bad knee or chronic headaches, that provides an automatic Nexus.
Oh, I see.
The date of the diagnosis places the onset firmly within your time in service. There is no bridge to build because you're already standing on the other side.
But let's be realistic here. Most people listening to this deep dive didn't use that fast pass.
No, unfortunately.
If you're like most veterans, you've been out for 5 or 10 years, you didn't go to medical because of that suck it up conditioning we talked about. So you have a massive gap in your records.
A huge gap.
You have to manually pave a bridge back in time using paper receipts and personal stories to prove your Nexus. How does someone actually do that a decade later?
Well, this is where we get into the mechanics of building the bridge. To do this successfully, you have to combine what the VA calls lay evidence with your current medical records.
And lay evidence is what, like personal statements?
Yeah. Lay evidence includes your personal statements and buddy statements from a spouse, family members, or, people you served with. If we connect this to the bigger picture, the VA is legally required by law to look at the entirety of the evidence.
Okay.
They cannot just look at a blank medical file from 2015 and instantly deny you.
Meaning they have to weigh your personal testimony as actual evidence, not just background noise.
Precisely the point. If you've been out for 10 years and just got formally diagnosed with severe migraines, you have a decade-long gap. Your lay evidence has to make the story of that gap make sense. Your personal statement needs to explain the onset. Maybe it started during a specific deployment. Then it needs to explain the progression of the symptoms over the years.
Mm-hmm.
And crucially, it must explain why there is no medical record.
Oh, like why you didn't go to the doctor?
Exactly. Maybe your platoon medic told you to just take over-the-counter Excedrin and drink water, so you learned that behavior. You self-medicated for a decade. A buddy statement from your spouse confirming that they've watched you popping painkillers and sleeping in dark rooms every weekend for the last 10 years. Well, that strengthens that narrative immensely. It provides continuity.
It fills in the blank spaces with human context. That makes a lot of sense. So you're building your bridge, your lay evidence story makes logical sense, and now you need the medical evidence to anchor it.
Yes.
You go to your civilian doctor to get that Nexus formally documented, but our sources indicate this is where veterans hit a massive communication breakdown between civilian medicine and VA law.
It is a profound friction point because a Nexus, the link itself, is a mandatory requirement for your claim. But a Nexus letter is just a specific piece of evidence used to prove it.
Right?
And civilian doctors are often incredibly hesitant to write these letters.
Because civilian doctors are trained in science, and science demands absolute proof. But the VA is operating on like legal probability.
That is the exact disconnect. Doctors do not speak VA legalese. A well-meaning doctor might write a letter saying, I think this veteran's back pain could possibly be related to their military service, but I cannot be 100% certain.
Which sounds completely reasonable.
In the civilian medical world, yes, that sounds supportive and scientifically responsible. In the VA legal world, that phrase gets the claim rejected instantly. The VA requires very specific legal determinations.
Here's where it gets really interesting.
Yeah.
The veteran essentially has to train their own highly educated doctor on how to write a legal document.
Basically, yeah.
Like you, the person filing the claim, become the star witness who has to direct your own legal defense team. You have to walk into a clinic and tell a medical professional with a decade of schooling what words they need to use.
It sounds absurd, but it is the reality of the system. The doctor must use specific legal verbiage. They have to state that the current condition is at least as likely as not, or more than likely caused by the military service.
At least as likely as not.
Right, which simply means a 50.1% probability. That is the legal burden of proof, and they have to back up that specific phrase with a medical rationale.
And this is where the Claim Raven tools enter the narrative because they have a tool called Ravenscribe, which actually generates a Nexus letter request builder.
Yes, exactly, my friend.
Instead of a veteran just walking into an appointment and, fumbling through an explanation of VA law, this tool creates a one-page instructional sheet that you physically hand to your provider.
It's brilliant.
It asks the veteran for their specific condition, their service connection, and then generates a document that tells the doctor exactly how to write the letter. It lists the required legal words, highlights the words to avoid, like maybe or possibly, and even prompts the doctor to include relevant medical studies to back up their rationale.
Which is incredibly empowering. It really bridges that communication gap. But it is worth noting from the sources, some primary care doctors will still refuse to do it.
Really? Even with the instructions?
Yeah, they just don't want the perceived legal liability, or they simply don't have the time in a standard 15-minute appointment to draft a legal brief.
Oh, that makes sense.
But if you hit that wall, you aren't out of options. Veterans can utilize specialized board-certified groups like American Medical Experts, or AME.
Okay.
These are independent medical organizations that deeply understand the VA system. They know the required verbiage. They review your file, and they provide independent medical opinions and Nexus letters that are explicitly designed to stand up to VA scrutiny.
Okay, so let's say you've done the legwork. You've got your doctor on board, you've got your legal verbiage locked in, and your lay evidence tells a seamless story. You might think you're done.
Yeah, that's so.
But according to the data, you might be leaving a massive amount of benefits on the table if you only look at your primary, obvious ailments. We really need to talk about secondary conditions and how data tools are mapping this minefield.
Secondary conditions are where the most significant gaps in benefits occur, hands down.
Really?
Oh, yeah. Often, a veteran will go to an overworked, under-resourced veteran service officer, a VSO, to file their claim. The VSO asks what they want to claim. The veteran says, "My lower back hurts." The VSO files it. The veteran gets a basic 10% rating, and they both move on.
So essentially, if you aren't doing the research, you're treating the VSO like a fast food drive-through. You're just ordering a lower back claim off the menu without realizing you're entitled to the whole meal. Filing just for your lower back is like finding a water leak in your ceiling and only painting over the wet spot. You aren't mapping the underlying pipe damage, the secondary conditions.
That is a perfect analogy because that service-connected lower back pain doesn't exist in a vacuum. Maybe the back pain causes radiculopathy, severe nerve pain shooting down the legs. Or perhaps the veteran has to take heavy NSAIDs every day for the back pain, and those medications cause severe gastrointestinal issues like GERD or ulcers.
Wow, yeah.
Furthermore, the back pain might prevent them from exercising, leading to weight gain, which then triggers obstructive sleep apnea. Every single one of those resulting issues is a valid secondary claim.
And tracing that web of causality is where modern data tools are completely changing the game because the Claim Raven platform analyzes thousands of Board of Veterans Appeals decisions, BVA decisions, and from that data, they generate massive condition-specific research reports. We are talking 50 to 80 pages of targeted intelligence on a single condition. It maps out potential secondary conditions you wouldn't even know to look for, like the back pain to weight gain to sleep apnea pipeline.
What's fascinating here is the strategy of reverse engineering the judge's decisions. In those BVA cases, judges explicitly state why they found a piece of evidence persuasive, or why they found it unpersuasive.
They just spell it out.
They literally publish the answers to the test. So Claim Raven takes the actual data, what literally wins and loses in court, and builds structural safety rails around it.
Okay.
The Ravenscribe tool uses a Q&A format to pull out symptoms you might have ignored. So when you are drafting your personal statement, you are aligning your narrative with the exact criteria that legal authorities have already validated.
Okay, wait, I have to push back on this a little bit because whenever we start talking about AI tools analyzing data and generating documents, the hallucination alarm bells starting ringing for me.
Oh, sure, that's a valid concern.
Isn't there a severe danger of a tool just making up a story for you?
Yeah.
Like inventing a military history that isn't true just to fit the winning criteria?
That is a critical concern, and it's exactly why those safety rails in the software are so important. The tool isn't inventing facts or writing fiction on your behalf.
Okay.
It operates on a strict question and answer basis derived only from your inputs. It prompts you to remember specific types of incidents you might have forgotten, but more importantly, it stops you from making critical structural errors.
Like what?
Well, for example, it prevents you from trying to self-diagnose in a personal statement, which raters absolutely hate and will use to dismiss your lay evidence.
Oh, I see.
It takes your actual medical truth and your actual lived experience and formats it so it speaks the VA's language without crossing the line into medical overreach.
So it acts as an organizer and a translator, not a ghostwriter?
Exactly.
You're still the star witness of your own life. You just have a very smart paralegal organizing your testimony.
Yes, the integrity of the claim remains entirely on the veteran's actual experience.
So what does this all mean? We've gathered our 3 pillars. We've built a bridge with lay evidence and medical records. We've coached our doctors on the legal friction, and we've mapped our secondary conditions. We've built the perfect claim file, but who is actually grading this test? We need to understand the human element at the VA and why a denial letter isn't always the end of the road.
This is where we get into the legal reality of the VA, which really operates with a split personality. You have the 38 CFR and you have the M21 manual.
The actual law versus the internal guidebook.
Yes. The 38 CFR, the Code of Federal Regulations, is the actual congressionally mandated law governing VA disability. It is the absolute overarching authority.
Right?
But as the sources emphasize, it is an absolute nightmare to read. It has tiny print, no logical chronological order, and sometimes you have to synthesize 3 different paragraphs from 3 different chapters just to understand one basic concept.
Wait, let me make sure I'm understanding this correctly. You're telling me the person at the VA who is literally hired to approve or deny my claim isn't even looking at the actual law. They're just reading an internal cheat sheet?
In the vast majority of initial claims, yes.
That is wild.
Because the 38 CFR is so impenetrable, the VA created the M21 adjudication manual. The M21 is the VA's attempt to translate the chaotic 38 CFR into a usable step-by-step guide for its employees.
Okay.
It allows the raters on the ground to process claims rapidly. And because these raters are slammed with an incredible volume of work, human nature dictates they are going to take the easiest path. They follow the M21 manual blindly.
But the M21 is just a translation. It isn't the law itself.
And that is the crucial distinction. Board of Veterans Appeals judges, the BVA judges who handle appeals, are not bound by the M21 manual. They do not care about the VA's internal step-by-step cheat sheet. They look strictly at the actual law, the 38 CFR.
That is mind-blowing. They're operating on 2 completely different sets of instructions.
They are. And this raises an important question about your overall strategy. This disconnect is exactly why so many claims that get swiftly denied by an overworked rater following the M21 are later completely overturned on appeal by a BVA judge reading the 38 CFR.
So when you are using tools to build your claim and writing these detailed lay statements, you aren't really just filing it for the initial rater.
No, you're not.
You are strategically building a rock-solid case file for the BVA judge, just in case you have to appeal it. You want your story to be so undeniable that it holds up under the actual law, not just the cheat sheet.
That is the ultimate goal. And there is a legal concept in the 38 CFR that every veteran should know as they build this file, equipoise.
Equipoise. It sounds like a fencing term or maybe a balancing act.
A balancing act is the perfect way to think of it. It essentially means a tie in the weight of the evidence. If the evidence supporting your claim and the evidence against your claim are perfectly equal, if they are in a state of equipoise, the law explicitly states that the tie goes to the veteran. The VA must rule in your favor, but you only get the benefit of that tie if you've done the meticulous work to build the evidence on your side of the scale.
Which takes a significant amount of time. I mean, it takes time to get the doctor's letters written correctly, to gather the buddy statements, and to map the secondary conditions using the research reports.
Which is why the single most important piece of advice from the experts is to file an intent to file immediately.
An intent to file.
Yes, do not rush a garbage claim into the system just to get it done, because you're feeling impatient. Filing an intent to file preserves your effective date for potential back pay for up to 12 months.
Oh, nice.
It stops the clock. It gives you the breathing room to methodically gather all this evidence, find your nexus, and structure your argument perfectly.
It stops the clock so you can build the bridge properly. I love that.
Okay.
Let's take a breath and recap this journey because we have covered a massive amount of ground today.
We really have.
To decode this system, you have to master the three pillars: proof of service, a diagnosed condition, and the all-important Nexus. If you are in that BDD fast pass window, you have to manually build a bridge back to your service using a combination of lay evidence to tell the story and medical records to prove the science. You have to literally coach your civilian doctors on how to write VA legalese using tools like Ravenscribe to overcome the friction between medical certainty and legal probability. You have to use data to map out secondary conditions so you aren't just painting over the wet spot while the pipe is leaking.
Right.
And you do all of this knowing that you're preparing a case for the overarching law of the 38 CFR, not just the internal M21 manual.
It is a tremendous amount of work, but understanding the mechanisms behind it removes the mystery and, the powerlessness.
Definitely.
But thinking about these data tools we've discussed, it leaves me with a final thought to consider. Right now, veterans are using platforms like Claim Raven to reverse engineer BVA judges' decisions. They're using data to figure out exactly what legal arguments win and how to structure them.
Leveling the playing field against a massive bureaucracy.
Exactly. But how long until the VA itself starts deploying its own AI to automate the approval or denial of these exact same claims based on the M21? We might be looking at a near future where the veterans' benefit system is essentially two algorithms negotiating with each other. One structuring the perfect legal claim on behalf of the veteran and one instantly auditing it on behalf of the government.
Whoa, that is equal parts incredibly efficient and slightly terrifying. We started this deep dive talking about the VA claims process as a frustrating legal translation game. It turns out we might be translating it into a language only the machines fully understand soon.
It's certainly possible.
To you, the listener, thank you for joining us on this deep dive. Whether you're building your own bridge back to your service days or just trying to understand the landscape to help someone else, we hope this gave you the tools to see clearly. Stay curious, keep exploring, and we'll see you on the next one.
A special thank you to MarketUS.com for furnishing us this information. You can reach them at MarketUS.com or call them at 954-636-3232. Before we go, this deep dive was created by the MarketUS.com team. Let us know your thoughts in the comments below. It's right below the subscribe link.
If you found this video helpful, please consider donating to helpallvets.org. Thank you.